Welcome, everybody. Today we have with us privacy guru and expert Phillip Brudney, who's going to give us a quick overview of the latest string of privacy regulations out around the state of Virginia. Phil, thanks for being here. I'm excited.
Morning, Christian. Thanks for having me.
Yeah, absolutely. So just for context, I don't think it's any secret that privacy is a hot topic socially and politically in terms of the amount of regulations that are being released. Pretty much the entire globe's familiar with GDPR at this point. California released CCPA. Then they did an update to CCPA, which is going to be out in, I think, 2022, called CPRA. And they established the first, agency to enforce the law here in the U.S. For the state of California. 20 plus states, I don't know how many at this point, I've lost count, have released privacy regulations in one form or another. And the latest in that string of releases is Virginia. So, Phil, can you just give us the background? What is the nature of this privacy regulation that Virginia has released? What's the bottom line?
Yeah, so I think Virginia really caught a lot of people by surprise. You mentioned all the other states that are working through these things in various draft forms. Virginia, in their 2021 session, just had a very concerted push from both sides to get a privacy law together. Uh, Within 2 months, they were able to pass it, get it to the governor for signature, and it's now law. It'll be effective January 1st, 2023. Um, Looking at it, I think it clearly draws on a lot of GDPR concepts, a lot of similarities to the new CPRA in California. So it's a lot of similarities there and a fairly comprehensive legislation.
Sure. So, like, for example, I know GDPR is applicable to basically everybody, all EU citizens, and also any company that is collecting data on EU citizens. So it's the most broad-reaching law. California is largely relevant to California residents, and then especially those companies that are doing data aggregation or buying and selling data. I think they have some exclusions around small businesses and things like that. For example, what does Virginia seem to have targeted any certain group or excluded groups from applicability?
I think the exclusions are probably more interesting for Virginia. Um, so for one, there are exclusions as far as number of records to data held in the commercial context or in the employment context. So if you're just collecting data on your business partners, that doesn't count toward your threshold for the law. If it's just data on your employees, that doesn't count. So it's very consumer focused.
So, like,
It
very
also,
third party, you're not an employee, you're not a business partner
mhm,
kind of thing. Got it.
it's like you're interacting directly with consumers and collecting their data in that context. Um, the exclusions, they're also a little more broad than California. Exclusions there are some exclusions at the entire company level, like I believe if you're subject to FCRA, for example, the HIPAA, uh, they kind of go back and forth on exactly how HIPAA applies, but there are some clear carve-outs there.
You said there's an exclusion
Yep.
for FCR. That's the Fair Credit Reporting Act. So that's
Yeah.
heavily, if you're banking or in lending, those types of companies would be subject to FCR. So those types of companies are excluded from this law.
Correct.
Interesting. So that's some
Correct.
big players. So you think of, like,
Yep.
who does business in Virginia? In California, it's the tech giants. People know that. But who is it in Virginia? There's certainly some large banks there. So it's interesting that they excluded them. And FCRA, I can see why there could be some justification to that.
Yeah,
Cool.
and it could get a little interesting for like a conglomerate that just has specific business units that are subject to FCRA or HIPAA, whether the carve out is really for the entire company or if it's just specific units or types of data.
Yeah, that'll be an interesting analysis. So, like, what if you're a banking conglomerate, but you have, like, some, startup incubator that's doing something not quite related to banking, is that also excluded? Probably not. I don't think that's the spirit of the law.
Yeah,
But
that doesn't seem likely, but
cool. What
we'll
else?
see.
What other exclusions? So you have like FCRA, that caught my attention. HIPAA, they're going back and forth. Any other
hmm
important exclusions?
It'd be in the blog post, which you can see on our website. I, I went through those in detail. Those were the ones that really stuck out to me, though.
Yeah. What about so
GLBA as well.
OGLBA? So
Getting
basically, if you're
further into
banking, a lot of the
lenders.
banking regs exclude
hmm
you. What about did Virginia do anything around setting up an enforcement body like California? Have they done anything like that, or is there any news about how they plan to actually have any teeth behind this?
Yeah, it's a great question. So it does establish a fund for a privacy agency, but it's not clear that's going to be what the purpose of that agency will be exactly. It leaves the Attorney General in charge of all enforcement of the act.
Interesting. So, for those who may not know, I think California put aside a guaranteed $5 million per year fund
hmm
as an initial fund for California, which is laughably small, given how all the litigation and audits it takes to really enforce something. And then Virginia put one out, but they're ultimately going to leave it up to the Attorney General. I guess that makes sense because they're the law enforcement body of the state.
hmm
Makes sense. What about anything that companies need to do? So I keep likening this back to GDPR and CPRA.
Yeah.
So I think CPR is requiring a cybersecurity assessment every year. They're requiring, for example, contractual agreements to be in place. There's a lot of vendor management stuff. Is Virginia doing any of those type of things, or anything unique?
I don't think there's anything unique. I'd say any company looking at this law, looking at CPRA, and wondering what they're supposed to do, I'd look at the similarities. So I think you're clearly starting to see enforcement coalesce around a few things. So profiling, targeted advertising, um, the processing of sensitive data. So that's your like I always say, data about the individual and who you are,
Yeah.
including like biometric data, some health data. Um, what was the other one? Data of minors. That's also now really considered a type of sensitive data. So companies dealing with any of those things should be very aware of these laws, and they'll see a lot of similarity there. But the message is clearly these are what's on the mind of these U.S.-based regulators, and GDPR as well covers them. So think about a comprehensive approach, and
Yeah. I
with
mean,
that, the data protection assessment is really going to be mandatory if you're doing any of those activities.
yeah. So that's an interesting point. So GDPR requires a lot of stuff, including cybersecurity, but they call out specifically privacy impact assessment and data privacy impact assessments. California has a requirement for a cybersecurity assessment. They kind of allude to a privacy impact assessment. And then, and by the way, all of these terms are nuanced and can mean slightly different things from one regulatory body or one certification body to another. So if you're feeling lost with all these assessment activities, don't worry. So is everyone else. And Virginia has one. What did you say that was called? A data protection assessment? Or what is it?
I think they call it a privacy risk assessment.
Privacy risk assessment. Is that likened to the PIA that GDPR requires? Is that how you're interpreting that?
Yeah, definitely. It calls out exactly what it's looking for, but it says an assessment performed for purposes of complying with other regulations will probably be sufficient for Virginia.
Yeah. So this is a nuance to me because a lot of our clients come to us asking for a privacy assessment. So what I think it is one way to interpret all of these assessment requirements is we need an assessment of our privacy program, right? But that's not what they're asking for. Like that's a good thing to do if you're trying to build out a privacy program. We can come assess the state of your privacy program and make some recommendations and build a great privacy program. But when GDPR or Virginia or California talks about a privacy impact assessment or kind of any kind of privacy assessment, what they mean is that you do a risk assessment on the types of data you're collecting and then try to make some assessment about how that might negatively impact or what harms it might cause the data subjects. So if I'm collecting Phil's biometric data, someone internally needs to be doing some assessment to say, what could go wrong? Why might this be an issue? And if there are issues or risks, what are we doing to mitigate those to make sure that we don't accidentally violate the privacy of Phil? And I don't think that's not a natural motion for most organizations right now to perform that type of assessment and to perform it on an ongoing basis, because you're going to bring new products to market. Your products are going to have new features. Your engineers are going to be doing stuff that makes sense, like collecting troubleshooting data and all sorts of, who knows what on users. And the intent isn't to violate anyone's privacy, but there's the possibility for that. So you have to integrate into your program some process to keep evaluating that. A, it's the best practice, it's the right thing to do. And B, it's like it's now state by state being required from a regulatory perspective and GDPR. So anything else interesting about Virginia, Phil? Because I do want to zoom out and just talk about, for companies that are trying to build privacy programs and playing whack-a-mole with all the states, some things to consider. But any other kind of highlights for Virginia in particular?
I don't think I saw anything too unusual in there. Reading it when it came out, like right on the heels of CPRA, it was clear just a lot of overlap. They're really touching on the same topics and thinking the same way, headed in the same direction.
Yeah, I've talked to some folks. Actually, recently talked to a colonel in the military who does cybersecurity and privacy. Talked to a couple chief privacy officers, and I think there's no consensus on whether or not we're ever going to get a federal law. I think most of the folks in private sector have a strong inclination there's not going to be a federal law. So I don't know if there will be anything to unite all of this stuff regulatory-wise. But I think it's pretty much a guarantee that the states are going to continue to ratchet up their regulatory requirements as related to privacy. We know they're doing that internationally. And so the question is if you're a company and you're trying to build a privacy program, which, by the way, includes security. So what you're really saying is I got to build a security and privacy program. What do I do? Because you definitely do not want to fall in this trap of I have HIPAA, I have GDPR, I have CPRA, I have Virginia, I have Colorado, I have Georgia. You're not going to get in that game. It's not one you want to play. It's going to waste a lot of time and energy, and they're not that unique. Like, they're similar enough that if you put in place some privacy principles, you're going to be able to comply to those types of programs. I'm making that assertion. Phil, are you agreeing with that? That's kind of the trend you're seeing as well.
Yeah, I think that certainly Virginia and California, you see a lot of the same things, and more broadly, the privacy principles are out there. The key privacy activities that regulators tend to be concerned about, they're not changing rapidly enough that you're seeing a huge change in the regulators' approach.
Yep.
So I think you'll continue to see regulators focused on the same areas. You could see some broader changes over time, but right now there seems to be a clear set that they're focused on.
Yep. So just laying out the facts as a business owner, and this includes me and you, right? Because we're thinking about this at-risk 360.
Definitely.
One is privacy is here. Is here. It's here from a regulatory perspective. It's here from a public consciousness perspective. So we have to address security and privacy. So now the question is, like, what do you do? So business case is easy. Like, customer trust, if whether you're B2B or B2C, it doesn't matter. Your business partners or your end users are going to expect that you have a privacy posture. So to maintain your reputation, you got to do that. The second thing is we're seeing an uptick in contracts. I don't think I've signed a contract or reviewed a contract in the last couple years that didn't have security and privacy addendum in them. Some of them requiring formal certification, some of them just requiring, standard contractual clauses that you have to meet. there's a huge uptick in questionnaires and like vendor due diligence activity. So in many ways, if you're a service provider, you can't do business unless you have a story to tell around this, especially if you're doing any type of data collection. Like we do very minimal data collection and we still get hit with all of this stuff as a firm. And then the next thing is you don't want to get sued. So you have to have a legally defensible approach. You have to have a story to tell that's the right story. And it is reality. It's not just a story, right? You need to be able to say this stuff with confidence and be able to back it up. So it's kind of in my mind at this point, it's table stakes to do business. But you also don't want to overburden the business with all of this like compliance and regulatory stuff that has the perception or reality of being non-value add. So that's why when we're thinking about this, building out these security and privacy programs, when Phil and I and other privacy and security experts are thinking about this, we're trying to come up with a harmonized strategy to integrate security and privacy and compliance into the business without disrupting the business, but doing the right thing as well. So that's where we always point back to really the de facto certification for privacy right now, which is ISO 27701. Even if you don't want to get that certification, it's still a decent framework to consider. I'm going to rattle off a few things. So top level governance structure. So we talk about Information Risk Council or Office of Data Protection Officer. You have to have leadership buy-in and visibility into these programs. Otherwise, you don't have a leg to stand on, because if something happens, they're going to say, hey, who at leadership knew anything? And if you can't explain that, you're done. Then you got to do your risk assessments. Then you got to do your privacy impact assessments. You got to do data inventories. You have to have a story around cybersecurity. Obviously, you have to have policies and procedures to back all of that up. Then you have to have an awareness program, so the key individuals like your engineers, like your general counsel, like your leadership are aware of this whole program. Then you want to do spot checks, so like an annual assessment or an internal audit to make sure everything's going like you expect it's going, and to report those KPIs up to leadership. And then you want to have the resources dedicated to it to actually manage the program. So that means people, that means money, that means tools. That's a short list, but a lot packed in there. But that's generally what 27701 wants you to do. And if you do those core set of things, guess what? You're going to be compliant with pretty much all of the regulations out there in some meaningful way, or at least way down the path of compliance. And maybe there's some nuances you have to address in between. But I just want to throw it out there because I think it's really challenging for businesses right now, because the temptation is to comply with these as they come down, when really there's 90+% overlap between all these regulations. You just need to implement a set of best practices and principles and adhere to those. You agree with all that, Phil? I see you're nodding your head. Anything you want to add to that?
Yeah. I'd emphasize the management layer, I think, is one reason I like ISO 27701 so much. It picks up on something that GDPR never requires you to have, like this management outside of the data protection officer, but it's so valuable to your program overall, and being able to address these new regulations, understand your overall posture, and figure out how you're going to comply with the new regulation.
Yeah, absolutely.
So that's just hugely valuable for how you handle these changes.
Absolutely. So if you guys like this kind of content, or you want additional help, you want to think about how to build a security or privacy program, or you just want to do some education for yourself, point everyone to a few resources. First of all, you can go to the risk360.com website and check out our white papers. You can filter it by privacy or GDPR, and you can see a lot of great thought leadership that Phil's largely pioneered, that it breaks out these different regulations in very human readable format with some action plans on things you can do to start building that program. I think those are great starter resources. The other thing you can do is go to our YouTube channel. So just go to YouTube and search for Risk360. We have a privacy playlist that every regulation that comes out, we try to do a video just like this where we talk about how to get through it, or if you're looking to get certified, how to consider doing that. And then obviously we have a podcast as well. So you can go to your favorite podcast app and look up Risk360 and get this if you prefer to listen to it instead of looking at our beautiful faces during this. But I think between those three, those are great resources for everyone. We also have a blog. Phil, I think you said you wrote a blog post. I read that blog post around the Virginia where there's a breakout of that. So those are great resources. They're free. You can get them from our team. to kind of self-educate. And obviously, if you need some expertise and down in the grain and the nuance to implement this and at your organization, reach out to myself, Christian Hyatt at risk360.com, or Phil Brudney, and we'll be happy to help. Phil, thanks for this breakdown. Appreciate you sharing your knowledge.
Enjoyed it.
Awesome.